European Parliament has any force or effect over here. It doesn't. These are the facts in basic brushstrokes. In 1999, the House of Lords Reform Act, it took away the House of Lords power of veto. That means that every single act since 1999 is a nullity at law. That means it cannot be enforced except with the consent of the people. So we only have to withdraw that consent. The reason for this is, under the Constitution, and this cannot be changed, it's written by Blackstone in his commentaries on the laws of England, it's written by many other people besides. On the day, the very day, the moment in fact, that Parliament was not two houses, one of which, the House of Lords, could always veto a bill or an act that they believed wasn't to the benefit of the people. That is no longer possible and hasn't been since the House of Lords Act in 1999, which means all of the statutes allegedly giving legal effect to parking banditry of all natures, so that's all the parking bandits out there, the councils and the private companies, all of those statutes that they rely on every time, null and void, cannot be enforced. That's why if you ever have access to a legal database, have a look for one piece of case law establishing the legal right to levy with fines for any purpose whatsoever without the judgment of a court. That's Article 12 of the Bill of Rights. No fines or forfeitures without the order or judgment of a court. I've been into the county court against Nottingham City Council parking bandits. I won, I had it struck out without attending, and I had it struck out because I delivered a skeleton argument to the judge, which he agreed with on every point. And in that, I made it perfectly plain that it was all void ab initio, void from the beginning. Constitutional law breach. But more than that, I was saying to some people outside, this is very important, whatever you receive in law is whatever you accept that you are presented with. It doesn't mean whatever is served, or whatever is dispatched, or whatever is delivered, or whatever is posted, because someone might post you a dog turd. You don't have to accept that. Well, what if you think, as I do, that when you get a parking ticket and the subsequent notice to owner that it's as good as a dog turd and put it in the bin? Didn't receive that. Anyway, it's void ab initio because it's a breach of constitutional law. I can rely on that if it ever goes to court. Well, it very often does. First time it goes to court, it'll be Northampton Court, Bulk Centre, County Court, Bulk Centre, more than likely, or another Bulk Centre. When it does, goes to the Bulk Centre, it's being dealt with by a computer. On the back, it says, tick a box if you didn't receive the notice to owner. If you didn't receive it, that means if you didn't accept it. All these points have been put to the judge in the county court. He was a district judge. He's got a reputation as being a bit of a scholar. He's written on the law and procedure, and he did not take issue with anything that I'm putting forward to you. None. And he threw out the claim of Nottingham City Council. They did not have a leg to stand on. They were trying to allege that it was contempt of court because it was received. What they really meant to say was, it was delivered. And they couldn't prove that it was delivered with a mail receipt even. If there's no evidence, there has to be a reasonable doubt that they can't possibly win. This is all on Free the Planet. The entire argument that I used, you can get it there. Okay, so the position for most people is not one that can be easily negotiated. Therefore, we've managed to create a system that's at present as simplified as it can be. It's being more simplified as we speak. There are more and more people who are coming forward and offering their help and their support and their services to the Universal Community Trust. However, the one thing that makes it all feasible is that what I'm saying to you comes to pass with regard to the lines of credit. When all of you can set yourselves free from debt slavery, who here wouldn't have a different life? You wouldn't.
Oh yeah, I would, sorry.
So is there anyone in the room whose life wouldn't be different if they didn't have to slave for the dollar? Okay. Now how many people, seriously, even if you did want to have a break because you've had your nose to the grindstone for so long. How many of you have not got something that you'd really like to do with your lives? Not one. I think that applies to everybody. I don't believe anybody came here with nothing to do. I believe that everybody's unique mission is to make a contribution that no one else can at this time. And yet, how many people do you know in your lives that are able to do that? Because of the extent of the deception. Okay, how long have I been talking? How long is it? Hour and a quarter. Okay, shall we have a short break? Yeah? Okay, we'll have a 15-minute break and come back. So, I think I want to just, at the beginning of this session, I just want to focus on a couple of the issues. That I said I would be talking about tonight, because I am aware that there are quite a few of you in the room who may not be familiar with what I did with the taxman and what I did with the registrar. So, we'll start with the registrar. Okay, so I was talking with my wife when we were pregnant with our daughter, and I say we, I know it wasn't actually physically true, but it felt like it, and it still does. But nevertheless, my wife still has one foot in the matrix. She's a teacher in an independent school. She teaches ethics, religious studies, and philosophy, and she gets letters from students thanking her for teaching them to think. So she's not giving them anything on the curriculum, she's giving them something which they're not getting very much elsewhere, which is very, very good. I'm sure there are many others out there, so-called fifth columnists, veering off the curriculum and telling people to think for themselves instead of just repeating everything. Anyway, we decided together that on balance, neither of us, no matter, even though I didn't have any anxiety or fear over it, my wife's anxiety and fear over what the so-called authorities might do if we refused to register were completely blown away by our joint goal to make sure that nothing, not one single penny, was going to be spent using her name to finance an illegal war against anybody in any part of the world, or any kind of war. And the reason that we took that position is because there's an act of Parliament called the Government Annuities Act 1929. That's Government Annuities Act 1929. And this act gives a very unusual power to the National Debt Commissioners, who have appointed on their behalf the Comptroller General as the officer who can create, under the Government Annuities Act, life annuities in the name of any person they deem fit. Any person they deem fit is every person who is registered with a birth certificate. Immediately upon registration, the notification goes to the registrar. The registrar notifies the designated Crown Officer, and the designated Crown Officer will notify someone in the National Debt Commissioner's office. Then the Comptroller General will facilitate the paperwork that creates a life annuity in the name of that child. A life annuity is a perpetual, it's an instrument that is a perpetual generator of credit. It is no debt. If you've got an annuity that starts out with a value of £1 million, it has an interest payment which is paid either quarterly or annually, depending on the type of annuity. Let's say it's annually at 10% interest. So it's at £1 million, and over the course of a year, it will gain 10% in value. And the next year, it carries on, and so on, and so on. So every single year, it gains that amount in value, the interest. It gains in value. So, this annuity is sitting there in an account, or the dividend for this annuity sits in an account waiting to be claimed by the guardians of the beneficiary. That's the child. But because these facts were never disclosed to the parents, and because they don't generally look on the statute law databases, they had no knowledge that this annuity was created. And after 7 years of lying unclaimed in that account, under the STKV Act 1666, which is with regard to property that would seem to have been abandoned for the benefit of the reduction of the national debt, as per the terms of the Government Annuities Act 1929, the Comptroller General claims that beneficial interest for the Crown and puts it in the consolidated fund, which is really their war chest. That's why we refuse to register the birth of our child, in the main. In addition, there are a few other things, and I think it's best expressed by reading the declaration that we sent in response to notice requiring a qualified informant to give information for the registration of birth. I'll read a bit of that just so we can get into the mood. To my wife, at the address, on the date. Under Section 2 of the Births and Deaths Registration Act 1953, the duty is placed on you to give information to me of the particulars required to be registered concerning the above birth within 42 days of the date of that birth. It appears that you have failed to discharge this statutory requirement. Now, therefore, in pursuance of the above Act, I hereby give you notice and require you to attend personally the Register Office, Civic Centre, Newcastle, on the date, to give information to the best of your knowledge and belief of the particulars required to be registered concerning the birth and to sign the register. I shall be in attendance at the place appointed on the following days at the following times. Listed dates when the registrar is available for the meeting. If you fail to comply with this requisition, you will be liable for prosecution. And then just the bollocks on the bottom, reiterating the same. It's a punishable offence to disobey this statute, etc., etc. So that's what prompted the conversation, and this is what we said. Declaration of denial of consent to register children, strictly private and confidential. We, the authorised representatives for the legal persons, my name and my wife's name, do hereby declare that the following is a verified plain statement of the facts as we perceive them. Let it be known by all concerned, interested and affected parties that 1. We have been granted irrevocable superior guardianship rights over our children by the Creator of the universe. 2. We have accepted irrevocable power of attorney over our children's well-being and property until the 18th anniversary of their birth. 3. 4. On behalf of our children, we have settled their entire legal estate into a private trust which is administered for their maximum benefit. 4. The property settled into said private trust includes without limitation any and all information pertaining to the existence of our children, strictly precluding the disclosure of the details of their birth to any party whatsoever. 5. Any and all disclosures of information pertaining to the existence of our children would represent a breach of the aforementioned private trust, and all those parties responsible for said breaches will be liable for charges of £30,000 sterling, or functional currency of the United Kingdom, per occurrence. 6. We do not recognise or consent to any perceived obligation, whether statutory or otherwise, to register the births of our children under any circumstances whatsoever. 7. As trustees of the aforementioned private trust, we affirm jointly and without division that we refuse to grant our consent and or authorisation of the registrar or any other individual, organisation or legal entity to register information pertaining to the birth of our children under any circumstances whatsoever. And then it's just the declaration and both of our autographs and the seal. So, now, what would you imagine happened after we sent that? Well, should I put you out of your misery and read you what they sent in response to that? There's no title on it, but it should be called, "Now look here!" Dear Mrs. Title she doesn't recognise. I have written to you on a number of occasions regarding the registration of the birth of your daughter. Well, that's 30 grand for a start. She was born on the 11th of June 2010 at the place of birth. Well, there's another 30 grand. I have no alternative but to report your failure to register